Good morning. This is John Rhodes, Chair of the Public Service Commission and Chair of the Siting Board. I'd like to call this meeting of the Board on Electric Generation, Siting, and the Environment, to give it its full name, to order. Before we get started, I would like to note our arrangements for the meeting today. In line with the guidelines concerning social distancing and minimizing large gatherings, and in keeping with the executive order suspending provisions of the Open Meetings Law on an emergency basis, we're conducting today's meeting remotely. I would like to remind those who are participating by phone to please mute your lines except when you are speaking. The public will have the opportunity to listen to the meeting by going to the department's webcast page, and we will also record and transcribe the meeting as has been our practice. These arrangements have been reviewed by our General Counsel, and he has found that they meet the requirements of the executive orders and that they meet my own expectations of honoring the intent of the Open Meetings Law. Before moving to the next items and introductions, can I just do a sound check? Am I coming through audibly and clearly?
Yes, you are.
Perfect, thank you. So then before we move to the agenda, I would like to introduce the alternates representing the permanent members of the Siting Board, and I'd like, after I name them, for each of them to note that they're on the call or in attendance or here or whatever. Louis Alexander, alternate of Basil Sagos, Department of Environmental Conservation.
Present.
Thank you. Dr. Elizabeth Lewis-Michael, alternate of Dr. Howard Zucker, Department of Health.
Present.
Thank you. Vincent Ravishir, alternate for Eric Gertler, Acting Commissioner, New York State Department of Economic Development, and President and Chief Executive Officer Designate, Empire State Development.
Present.
Thank you. And John Williams, alternate to Richard Kaufman, New York State Energy Research and Development Authority.
Present.
Thank you. Secretary Phillips, are there any changes to the agenda?
There are no changes to the agenda.
Thank you. So with that, let's get into it. Case 15F-0122, application of Barron Winds, LLC, for a certificate of environmental compatibility and public need pursuant to Article 10, construct a wind energy facility. There are two matters presented for our consideration. The first, concerning a rehearing petition, will be presented by Marina Chowdhury, Assistant Counsel, Department of Public Service. Bacon McCakes, Chief Administrative Law Judge, Robert Rosenthal, General Counsel, and Brian Osias, Managing Attorney, Department of Public Service, are available for questions. Ms. Chowdhury, please begin.
Thank you, and good morning, Chair Rhodes and board members. Before you today is an order denying a petition for rehearing of the board's May 6, 2020, order approving amendment regarding the Barron Winds LLC amendment petition. On September 12, 2019, this board granted a certificate of environmental compatibility and public need to Barron Winds pursuant to Public Service Law Section 168. The certificate approved a wind energy project having a capacity of up to 242 megawatts to be located in the towns of Cohocton, Dansville, Fremont, and Wayland in Steuben County. Following that, on March 9, 2020, Barron Winds submitted an amendment petition requesting approval to modify certain project component locations and install potentially fewer turbines at an increased height for up to 26 of those turbines. That amendment petition did not seek a waiver of any local laws. The May 6th amendment order approved Barron Winds' request. Prior to the amendment petition, the town of Cohocton had enacted Local Law Number 4 of 2019, amending the zoning law of the town of Cohocton and Local Law Number 2, which increased the allowable turbine height in the town. The arguments on rehearing are all with respect to this Local Law Number 4. Briefly, the petition alleges that in issuing the amendment order, the board failed to consider comments regarding Local Law Number 4 and the town of Cohocton's plans to repeal Local Law Number 4. And that the Department of Public Service failed to investigate a claim questioning the validity of Local Law Number 4. As an initial matter, the petition for rehearing rehearing was not filed within the 30-day statutory period for petitions for rehearing following that amendment order. The order before you accordingly finds that the petition for rehearing was not timely and is denied. Notwithstanding that denial, the order before you finds that the petition for rehearing failed to make an adequate showing that the board committed an error of law or fact, or that new circumstances warrant a different determination. The board considered local law number 4 when assessing the amendment petition. At the time the record closed on the amendment petition and at the time the amendment order was issued, local law number 4 was in effect. The board, therefore, appropriately considered local law number 4. Further, despite the claims in the petition for rehearing, in the amendment order, the board had considered and addressed comments it received regarding local law number 4. The amendment order notes that some commenters had filed comments stating that the town of Cohocton voted to repeal local law number 4. After considering those comments, the board determined that local law number 4 was still in effect. As to the petition's claims that the town of Cohocton may, at some point in the future, repeal local law number 4, Article 10 does not require the board to reevaluate projects for compliance with new local laws enacted after the board issues a final determination. Accordingly, the order before you denies the petition for rehearing and the alternative motion. That concludes my presentation, and I'm available for questions. Thank you.
Thank you, Norina, for that clear summary. I'm persuaded by the draft and by your summary. I find this decision that you propose is proper. It's well-grounded in the facts and the record and the rules, and I am going to agree. Do any of my colleagues have any comments or questions? Lou Alexander?
Thank you, Mr. Chairman. I have no questions.
Great, thank you. Betsy Lewis-Michael?
No questions.
Thank you. And Vincent Ravishir?
No questions, thank you.
Thank you. And John Williams, any comments or questions?
Thank you. No questions.
Thank you all. With that, I will proceed to call for a vote, and we will, as per our standard practice, do it in a roll call format. I'm John Rhodes, and my own vote is in favor of the recommendation to deny the petition for rehearing as just described. Mr. Alexander, how do you vote?
I vote in favor.
Thank you. Dr. Lewis-Michael, how do you vote?
I vote in favor.
Thank you. Mr. Ravishir, how do you vote?
In favor.
Thank you. And Mr. Williams, how do you vote?
I vote in favor.
Thank you. The matter is approved and the recommendation is adopted. We'll proceed now to the second matter. And this next matter presented us today concerns several compliance filings and will be presented by Heather Benke, Assistant Counsel, Department of Public Service. Bacon LaCakes, Chief Administrative Law Judge, Robert Rosenthal, General Counsel, and Brian Osias, Managing Attorney, are again available for questions. Ms. Benke, please begin.
Good morning, Chair Rhodes and members of the board. I'm going to present a discussion of the compliance filing that is in front of you today. As noted by my colleague, Norina Chowdhury, on September 12, 2019, this board granted a Certificate of Environmental Compatibility and Public Need to Bear & Winds, LLC, pursuant to Public Service Law, Section 168. The certificate order contains certificate conditions that require several compliance filings by the certificate holder, including conditions for construction and operation impact mitigation, to be approved by the Siting Board or the Public Service Commission once the Siting Board's jurisdiction has ceased. Under Public Service Law, Section 168, subsection 7, quote, following any rehearing and any judicial review of the board's decision, the board's jurisdiction over an application shall cease, provided, however, that the permanent board shall retain jurisdiction with respect to the amendment, suspension, or revocation of a certificate, end quote. For purposes of the compliance filings before you today, the Siting Board's jurisdiction has not ceased as the rehearing petition on the board's recent certificate amendment was pending before you today. The certificate holder submitted compliance filings on April 2nd, June 26th, and July 10th, 2020, pursuant to certificate conditions 45, 60, and 43, respectively. Each of these compliance filings is required to be made prior to construction. I will now briefly summarize what each of those compliance filings contains. Certificate Condition 43 requires the certificate holder to submit a project communications plan, which identifies the certificate holder's protocol for communication within the project organizational structure and the contact information for the individuals responsible at this time for project oversight. Pursuant to Certificate Condition 43, the project communications plan was submitted on July 10, 2020 by the certificate holder and was reviewed by DPS staff. The project communications plan, as filed, reasonably assures compliance with the Certificate Condition 43 of the certificate order. Certificate Condition 45 requires the certificate holder to submit a complaint resolution plan for both construction and operation phases of the project, including a separate procedure to address operational noise complaints developed in consultation with the towns. The plan must contain the methodology for submittal of complaints, the protocol for the company response to received complaints, and acknowledgement that if the project affects off-air television coverage, then cable television or equivalent service will be provided. Pursuant to Certificate Condition 45, the complaint resolution plan was submitted on April 2, 2020 by the certificate holder and was reviewed by DPS staff. The complaint resolution plan, as filed, reasonably assures compliance with Certificate Condition 45 of the certificate order. Certificate Condition 60 requires the certificate holder to make available $20,000 for recreational or aesthetic mitigation for the benefit of Loon Lake in the town of Wayland. The certificate holder is required to work with the town of Wayland to develop such mitigation plan. Pursuant to Certificate Condition 60, the Loon Lake mitigation plan was submitted on June 26, 2020 by the certificate holder and was reviewed by DPS staff. The Loon Lake mitigation plan, as filed, reasonably assures compliance with Certificate Condition 60 of the certificate order. In conclusion, staff recommends that the board adopt the proposed order approving the compliance filings. Thank you for your attention this morning. I'm available for any questions the board may have.
Thank you very much, Ms. Benke. It's John Rhodes. Thank you for the work, and thank you for, again, a very clear and straightforward summary. Both of those persuade me that the compliance filings before us are reasonable and assure a good accordance with the certificate conditions. In my own vote, and I'm going to be likely voting in favor of this recommendation. But before we proceed to vote, can I ask if there are any comments or questions from my fellow board members? Mr. Alexander?
I have no questions. Thank you.
Thank you. Dr. Lewis-Michael?
No questions.
Thank you. Mr. Ravishir?
I have no questions. Thank you.
Thank you. And Mr. Williams?
Thank you. No questions.
Thank you all. I will now proceed to call for a vote, and again, we'll do the roll call method. It's John Rhodes, just to confirm my identity, and my vote is in favor of the recommendation to approve the compliance filings as just described. Mr. Alexander, how do you vote?
I vote in favor.
Thank you. Dr. Lewis-Michael, how do you vote?
In favor.
Thank you very much. Mr. Ravishir, how do you vote?
I vote in favor.
Thank you. And Mr. Williams, how do you vote?
I vote in favor.
Thank you. The matter is approved and the recommendation is adopted. Secretary Phillips, is there anything further to come before us today?
There is nothing further for today.
Thank you very much. With that, we will adjourn. Appreciate everybody's work and attendance, and thank you all.